Mr. President means we're free. No, yes. Gee, Mr. President, you're a swell guy. You said it.
I'd like to welcome you all to the Heritage Foundation. I'd like to apologize for some confusion as to the schedule. Apparently, some conflicting notices went out. Some people arrived at 12 and some will probably arrive at 12:30, but I think by the time we get to the judge's lecture, it'll be just about 12:30. I'd also like to alert you to the fact that we are in the midst of compiling a mailing list of people who are interested in issues dealing with the Constitution. So if you would like to be informed of future constitutional lectures here at Heritage, I encourage you all to put your name and address legibly on the yellow pad which is located on the glass table out in the lobby. I believe this is the 7th in our series in celebration of the Bicentennial of the U.S. Constitution, and while Heritage does not have a judicial studies center, that given the fact that we are a public policy research institute, it is imperative that the people who are here in Washington responsible for public policy and the shaping of public policy understand that document that was fashioned in 1787. So without further ado, I'd like to introduce you to the director of our constitutional project, who is Bruce Fine, who has become, I think, perhaps one of the most prolific writers on the subject here in Washington, columns appearing practically every other day in the Washington Times and elsewhere. I'm pleased to welcome Bruce Fine, who will introduce to you Judge Minor.
Thank you, Ben. Today's subject is federalism, a concept that has certainly fallen into desuetude in Washington, D.C., and viewed, I suppose, as a term of disparagement rather than accolade to those who reside in Congress. But before we plunge into that for a subject with Judge Minor's trenchant comments, let me introduce Judge Minor, which is a personal privilege. I have known Judge Minor, I guess, for a couple of years, and I think he sits here as a legacy of the Reagan Revolution, perhaps the most important legacy of the Reagan Revolution, because he represents, I think, the highest and best judicial appointment that President Reagan will be renowned for once he departs office. And I think history will record that the appointments that Reagan has made to the federal bench, they say illustrated by Judge Minor and his great talent and capability, will be his most enduring legacy to public policy. Now, why do I say that? Even though judges do not sit in legislative fora, they don't sit in the executive branch, aren't, at least ostensibly, designed to fashion public policy, but to implement the policy charted by elected branches of government. And why should I say that, especially with regard to Judge Minor and others of Reagan's appointments who discourage judicial activism, judicial policy making? It's for this reason. In the United States, in the intellectual realm, what courts say and what judges say have a special impact, not only on the parties to the litigation, but on how Americans feel and conceive of public policy, whether it's wise or not. Courts and jurisprudence in the United States and the Constitution itself are especially revered by the people. Politicians, electorate, believes that what the courts say is not only correct legally, but it also carries some acceptability in the realm of morals and ethics and wise public policy as well. And therefore, it's exceptionally important, if we are to alter the dialogue that occurs in the Congress and amongst the people and on the op-ed pages, that we appoint judges of the stature of Judge Roger Minor, who, through their opinion writing, will focus and change the terms of the debate in explaining their judicial decisions. Now, Judge Minor is unique for several reasons. First of all, if you read his opinions, they glitter with both erudition and common sense. Now, that commingling is a rarity amongst federal judges. Some have erudition but no common sense. Others have common sense but no erudition. But Judge Minor is unique in combining those two. In addition, he does his own work. He writes his own opinions. He thinks through every case, not only yielding very profound decisions, but also displaying a commitment to judging that isn't found in those who detail law clerks to do their opinions for them. The latter habit is an earmark of sloppiness that often leads to error. And lastly, and perhaps most importantly, Judge Minor has an unsleeping quest for knowledge and truth when he examines any court case. He is not one of those who, just as Holmes lamented, accepted a rule of law because it was laid down in the time of Henry IV, and was around there because no one had the time or interest to challenge its continuing vitality. Judge Minor is unwilling to accept precedent simply because it's precedent. Always a search for a reason, always a search for whether or not the old rule of law, the old precedent, was correctly decided. And again, a rarity amongst judges who revere perhaps precedent more than anything else, in part because it's an excuse for not thinking. Should be reminded that the Supreme Court has overruled itself over 250 occasions, which indicates that, as Justice Jackson said, they are not final because they are infallible, but they are often deemed infallible because they are final. And one instance of Judge Minor's challenge here to conventional wisdom was his dissent in a criminal conviction in the so-called Foster Winans Wall Street Journal insider trading case. His dissent has seemed to have elicited some sympathy in the United States Supreme Court, and that particular case now is pending for review in the United States Supreme Court. Now, there's an additional reason why I think that Judge Minor deserves great applause, and that is because his mind is courageous. And what do I mean by this? It is often difficult to confront prevailing intellectual milieu amongst one's closest colleagues, and that's especially true in a judicial setting, where intimacy is not a choice, it's not an option, it's simply a fact. And of course we know in the judicial realm today, when one speaks out against judicial activism, it's not always easy and pleasant, because one is often confronted with remarks of hostility and ad hominem criticism. But Judge Minor is one of those few who has stood his ground, has challenged conventional wisdom without equivocation, with firm resolution to do what reason and knowledge tell him. It is only through such intellectual courage that we will ever make progress. We learn from the turtle. He sticks his head out, knowing that's the only way to move forward. And I underscore the importance of judges like Judge Minor in changing the way in which jurisprudence will evolve because of its criticality to public policy in the United States, since the Constitution itself is so replete and instinct with public policy preferences. Now, I would simply close, before Judge Minor begins his speech, with a remark from Julius Caesar. What was said of Brutus could be said of Judge Minor. His life was gentle, and the elements so mixed in him that nature might stand up and say to all the world, this was a man. Judge Minor.
In the few minutes remaining to me, I would like to introduce Bruce Fine, who just gave today's lecture. He reminds me of the name of a Chinese government official I just read about, On Too Long. I actually developed 2 cavities waiting for him to finish. But Bruce is the foremost constitutional scholar in the country. He told me so himself. He's a legend in his own mind. I've been following his career very closely since yesterday. He recently undertook the representation of a man accused of assault, robbery, and murder. He visited the man in jail and said, "My research discloses several constitutional defenses, any one of which will get you off. I shall continue my research and come back to see you in a few days. Meanwhile, try to escape." My father, who has just entered his 60th year of law practice, saw Bruce's televised appearance at the Senate confirmation hearings and told me that he thought my friend Bruce was brilliant. And that shows you what 60 years of law practice will do to a man's mind. He testified in favor of Rehnquist, right? He was confirmed anyway. I could say that Bruce is quiet, inhibited, and self-effacing. I could say those things, but they wouldn't be true. Anyway, in my opinion, he's a great guy. And in his, too. I'll let you in on a little secret. Bruce is so important here in Washington that he leaks information to the administration. He recently wrote a piece, among the many that he did, for the Washington Post, in which he recommended that the president immediately institute talks with the people who pose the greatest threat to the peace and security of the United States, the Russians and the Congress. And I really did appreciate Bruce's introduction. When I was United States District Judge, I daily received a different kind of introduction. I was preceded into the courtroom by a bailiff who would announce that court was in session and that Honorable Roger J. Minor was presiding. He then would turn to me and say, "God save the United States." I hope that nobody will consider the Republic endangered as the result of my remarks today. At any rate, I am pleased to participate in the Heritage Foundation's Bicentennial Lecture Series, and I now offer my modest contribution to that enterprise. Exactly 200 years ago this week, on February 21st, 1787, the Continental Congress adopted a resolution calling for a convention to revise the Articles of Confederation. The work of the convention was completed at Philadelphia 7 months later, on September 17, 1787. On that day, the framers signed the enduring document we celebrate and re-examine during this bicentennial year. It was no easy task to convince the citizens of the several states during the ratification process that the new Constitution did not pose a threat to their newly won independence. Fearing that a powerful central government merely would replicate the arbitrary ways of the British Crown, many saw a greater detriment than benefit in the formation of a more perfect union. One of the provisions of the proposed Constitution that caused the citizenry some concern was the portion of Article 6 that has come to be known as the Supremacy Clause. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or law of any state to the contrary notwithstanding. Writing as Publius in number 33 of the Federalist Papers, Alexander Hamilton sought to dispel the people's fears that the Supremacy Clause would lead to an erosion of their rights as citizens of the several states. Hamilton wrote that a larger political society, composed of a number of smaller political societies, would amount to nothing if its laws were not supreme. He pointed out, however, that the larger society should be treated as a usurper when it acts in excess of its constitutional powers and invades the residuary authority of the smaller societies. According to Hamilton, only those laws based on the enumerated and legitimate objects of federal jurisdiction would be accorded the dignity of supreme law of the land. Obviously, Hamilton's assurances were based on his concept that the national government was to be one of limited powers, that all other governmental authority remained in the states, and that any incursion into the residual authority of the states would be considered an illegal encroachment. James Madison used these words to describe his view of the division of responsibility. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The Federalists clearly were confident that the enumerated powers, specific and defined, would serve as a significant limitation on the exercise of federal jurisdiction. What they did not foresee, of course, was the expansive interpretation of the enumerated powers that would be provided by the third branch of government. It was, in fact, the anti-federalists who anticipated that the judiciary would be called upon to referee the frequent disputes that inevitably would arise under the Supremacy Clause. The anti-federalists predicted that the federal courts, by reason of their authority to decide when state law is preempted by federal law under the Supremacy Clause, would be the instruments by which state power would be reduced to naught. An article in the Essays of Brutus series, a different Brutus, published on February 14, 1788, urging rejection of the proposed Constitution, anticipated that ratification would spawn the following developments: adoption of federal laws duplicative of state laws in areas where state and federal jurisdiction is concurrent, extension of central government operations into those areas, and federal court condonation of these enlarged activities by liberal construction of the powers of the central government. As a result, according to Brutus, the rights of the states to act would be diminished to the point of becoming so trifling and unimportant as not to be worth having. It is generally thought that Brutus was Robert Yates, a New York judge who was a delegate to the Constitutional Convention. Yates left the convention before the Constitution was completed and later wrote to Governor Clinton of New York that he opposed the consolidation of the United States into one government. We New York judges always been known to be a little radical. Although the dire predictions of the anti-federalists have not entirely come to pass, some of the problems they foresaw 200 years ago are with us today. Certainly the Supreme Court has approved the exercise of broad-ranging federal authority, despite the limited powers envisioned by the framers. This, of course, has allowed the central government to act in many areas originally thought to be primarily of state concern. Accordingly, the Supreme Court increasingly has been called upon, in cases where state and federal legislation affect the same subject matter, to decide whether the state activity has been preempted under the Supremacy Clause. I propose in this lecture to reveal the confusion and inconsistency of the courts when faced with issues of statutory preemption. I also propose to show the consequent need for Congress to play a more active role in defining the scope of permissible state activity and in preserving the constitutional framework of federalism. It seems to me that the obligation of Congress to assure the states a proper range of governmental operations is implicated in the duty of the legislative branch recently described by the Attorney General, the duty to interpret the Constitution in the course of performing its official functions. Actually, the Attorney General said that this interpretive function is vested in all three branches, and I certainly do not mean to say that the executive and judicial branches have no part to play in the preservation of our federal system. My contention is that Congress, by being alert to preemption problems, can play a vitally important role in the protection of state autonomy. Indeed, as the branch of government closest to the people, Congress has a positive duty in this regard. I shall have some suggestions and recommendations on how that duty can best be fulfilled at the conclusion of this discussion. The Supremacy Clause was tested early on in a case arising out of the War of 1812. The state of Pennsylvania had enacted a statute providing for a state court-martial of members of the militia who failed to obey a call to service by the President of the United States. The penalties provided were those prescribed by federal law for the same offense. In upholding the jurisdiction of the state court-martial, Justice Bushrod Washington, writing for the Supreme Court majority, found it sufficient that the concurrent exercise of jurisdiction by the state and federal governments was authorized by the laws of the state and not prohibited by the laws of the United States. Although he found no repugnance between the two statutes in the case before him, he speculated that the will of Congress could be thwarted and opposed, even if it were possible to comply with state law without violating the requirements of a federal statute. Justice Story, in dissent, declared the narrower rule that in cases of concurrent jurisdiction, state laws would yield to federal laws on the same subject only in cases of direct and manifest collision, and then only to the extent that they were incompatible. Curiously, Story found the Pennsylvania Militia Act wholly incompatible with federal statutes relating to the same subject. When Aaron Ogden sued Thomas Gibbons to enjoin the operation of steamboat service between Elizabethtown, New Jersey, and New York City, he relied upon his ownership by assignment of the exclusive rights of navigation originally granted to Robert R. Livingston and Robert Fulton by the exclusive franchise granted by the New York State Legislature. The Supreme Court agreed with Gibbons and reversed a judgment of New York's highest court in favor of Ogden. In the opinion written by John Marshall in 1824, echoing the Story dissent in the militia case, the court held that its inquiry was limited to the question of whether the laws of New York, as expounded by the highest tribunal of that state, have, in their application to this case, come into collision with an act of Congress and deprived a citizen of a right to which that act entitles him. Having found such a collision, the court perceived no difficulty in deciding that the act of Congress was supreme, and that the law of the state, though enacted in the exercise of powers not controverted, must yield to it. In the opinion, the great Chief Justice wrote that the framers of our Constitution foresaw this state of things and provided for it by declaring the supremacy not only of itself, but of the laws made in pursuance of it. There you have it, a succinct statement of the doctrine of preemption as dictated by the Supremacy Clause. The elements necessary to invoke the doctrine were made clear. A state law enacted in the exercise of the sovereign powers reserved to the states, a federal law enacted by Congress within the enumerated legislative authority granted by the Constitution, and an actual, not theoretical, collision between the two. Simply put, state and federal statutes, though both be otherwise valid, cannot occupy the same space at the same time, and the state provision must yield. Despite the elegance and lucidity of the Gibbons opinion and the clear rule it established, some actual collision cases continued to be litigated and to find their way to the Supreme Court. In 1962, the court was presented with a clear collision between a state community property rule and federal provisions governing joint ownership of U.S. savings bonds. The federal provisions, of course, prevailed. And in 1977, 153 years after Gibbons, in a case involving issues virtually identical to those confronted in Gibbons, federal licenses covering mackerel fishery were held to prevail over Virginia statutes limiting the fishing rights of non-residents. These later cases may be more of a tribute to the fact that nothing can forestall litigation or impair the tenacity of lawyers in our nation than to the enigmatic nature of the president. Unhappily, preemption jurisprudence no longer is confined to questions of actual collision. The wide-ranging inquiry proposed by Justice Washington now has become the standard. In the name of the Supremacy Clause, the Supreme Court now examines state law to determine whether it is somehow inconsistent with the purposes of federal law, or is incompatible with a federal regulatory scheme, or interferes in some way with federal policy. In a case holding that the Pennsylvania Alien Registration Act of 1939 was preempted by the Federal Alien Registration Act of 1940, the court described the expanded scope of its inquiry as follows. This court, in considering the validity of state laws in the light of federal laws touching the same subject, has made use of the following expressions: conflicting, contrary to, occupying the field, repugnance, difference, irreconcilability, inconsistency, violation, curtailment, and interference. But none of these expressions provides an infallible constitutional test or an exclusive constitutional yardstick. In the final analysis, there can be no one crystal clear, distinctly marked formula. End of quote. The lack of a clear yardstick or formula has fostered the development of preemption jurisprudence on a case-by-case, statute-by-statute basis, devoid of analytic consistency and lacking in doctrinal intelligibility. It is difficult to disagree with the commentators who have written that the Supreme Court's preemption decisions have often produced considerable confusion and criticism, and that perhaps the most troublesome aspect of the doctrine of federal preemption has been its historically inconsistent application. The confusion and inconsistency are especially troublesome in light of the fact that preemption litigation has involved so many diverse areas of law and therefore has resulted in the displacement of numerous state regulations clearly adopted in the pursuit of legitimate state objectives. In the alien registration case I referred to earlier, the court held that a state statute requiring aliens to register and to carry a car to exhibit to police on demand was preempted by a federal statute requiring registration but not the carrying of a card. While there obviously was no collision in the Gibbons against Ogden sense, or even an actual conflict between the two statutes, the court held that Congress had occupied the field of alien registration, adverting to the supremacy of national power in the general area of foreign affairs, including the power over immigration and naturalization. The court saw the state law as an obstacle, blocking the achievement of congressional goals, although it is difficult to see how this was so. At any rate, there was no question that the state statute represented a proper exercise of the state's police power. The occupation of the field test, as applied in the alien registration case and in other cases, has been criticized for leaving open a number of questions. What standards should be applied in determining whether Congress has in fact occupied a field? Are there good reasons for finding exclusive federal occupancy? What are the boundaries of the specific field under examination? It seems to me that in applying the occupation of the field test and some of the other tests it developed to decide preemption issues, the Supreme Court has involved itself unnecessarily with policy problems, whose solution is best left to the other branches. Whether it is preferable that there be national uniformity in one area or another is not for a court to determine. It seems quite unexceptional to say that when it is not physically impossible for one engaged in interstate commerce to comply with both state and federal regulations, the state regulation is not preempted. This, in fact, was the principle underlying the decision upholding different maturity standards established by the state of California and the federal government to keep prematurely harvested avocados from the market. I guess Justice Scalia was right about some of the kinds of cases we get. This is the famous avocado case. The court found that there was no preemption because there was no inevitable collision between the two schemes of regulation, despite the dissimilarity of the standards. The fact that the two schemes had the same objectives was not held to be controlling. Yet a California labeling statute imposing requirements more stringent than those imposed by federal law with respect to weight variations due to moisture loss in flour was found to be preempted. The rationale there was that the purposes and objectives of Congress could not be accomplished and executed unless packages bearing weight contain the same quantity of the product. The purpose of the federal statute, according to Justice Thurgood Marshall, who authored the opinion, was to facilitate value comparisons by consumers throughout the country. It is difficult to discern just how there would be a problem with value comparisons when the state regulation was more strict than the federal. It is especially difficult to reconcile this case with the avocado case, since compliance with both flour labeling schemes was not a physical impossibility. Despite the dissimilarity of standards, there was no inevitable collision between them because flour manufacturers, knowing where their product is to be shipped, could pack and label to comply with state law as well as federal. The physical impossibility test certainly has not been consistent in its application. According to another test developed by the Supreme Court, state regulation is preempted where Congress has legislated so comprehensively that no room remains for the states to supplement federal law. This rule controlled the disposition of a case known as Rice against Santa Fe Elevator Corp., and later Supreme Court cases have cited Rice as authority for the rule. A close examination of Rice, however, reveals that there was perhaps some room the court overlooked, and that the displacement of state regulation there was another instance of policy choice. The case involved the regulation of grain warehouses under the Federal Warehouse Act and under certain provisions of Illinois law governing grain storage and storage charges. Although the federal regulatory scheme was a generalized one, revolving around the authority of the Secretary of Agriculture to issue and suspend warehouse licenses, and the state scheme was a particularized one, establishing specific warehouse standards and providing for rate regulation, the federal scheme was held to displace the states entirely. The court found that the Federal Act had been amended specifically to remedy past problems arising from a system of dual regulation. Having so found, the court ignored the areas apparently open to state regulation and leaped to the conclusion that the federal scheme prevails, though it is a more modest, less pervasive regulatory plan than that of the state. Justice Frankfurter, in a compelling dissent, disagreed with the proposition that Congress could, by merely touching a subject matter, render it untouchable by a state, though there is neither paper nor operating conflict between federal and state spheres of authority. Accordingly, he rejected the court's conclusion that the Federal Act inferentially deprived Illinois of a rate-fixing authority exercised over a period of 70 years while not conferring such authority on any federal agency. Frankfurter declared that the authority of states under the reserved powers always should survive unless Congress has clearly swept the boards of all state authority, or the state's claim is in unmistakable conflict with what Congress has ordered. It seems that the no room available test is open to interpretation as well. The Supreme Court has taught us that the critical question in any preemption analysis is always whether Congress intended that federal regulation supersede state law. The confusing and inconsistent rules and tests I have been discussing all were designed to divine congressional intent, express or implied. The word divine seems appropriate here because its dictionary definitions include to guess, to know by inspiration, intuition, or reflection, and to locate water with a divining rod. All these symptoms are applicable to the manner in which the court attempts to ascertain congressional intent to preempt. An expression of intent in explicit statutory language, however, should be conclusive. Unfortunately, it is not. An express provision for the maintenance of state jurisdiction was defeated in Pennsylvania against Nelson, a celebrated case in preemption jurisprudence. In that case, a state's Sedition Act was held to be displaced by the Federal Smith Act, which prohibited the overthrow of the United States government by force or violence. That determination was made in the face of a specific savings clause prohibiting the impairment of the criminal jurisdiction established under the laws of the several states. It is also noteworthy that Congressman Howard Smith, sponsor of the Smith Act, wrote a vehement denial that Congress ever had the faintest notion of nullifying the concurrent jurisdiction of the respective sovereign states. The preemption determination in Nelson was bottomed on the conclusion that the Smith Act was intended to occupy the field of sedition. Having previously written of my apprehensions regarding the nationalization of criminal law, I pause here to note that in addition to the general savings provision ignored in Nelson,